એઝ પર એક્ટ પર રૂલ્સ. જી
ઓનલી રિન્યુઅલ માટે છે. અને સાહેબ એમાં એવું છે કે ઓનલાઈન જે અપોઇન્ટમેન્ટ લેવી પડે એમાં સાહેબ 3 મહિનાનો સમયગાળો લાગે છે એટલા માટે.
પણ એમાં સાહેબ ઓસ્ટ્રેલિયામાં ટુરિસ્ટ વિઝા 3 મહિનાનો, મેડિકલ વગર મેડિકલ સાથે 6 મહિનાનો, એથી વધારે મળતો જ નથી. હા, એ તો પછી વાત.
રિન્યુ થઈને આવશે, નામદાર કોર્ટ સમક્ષ જમા કરાવી દઈશું સાહેબ. એની કન્ડિશન.
પણ એમનો પૂરો થાય છે 25/6/25, 12/6/25.
એની કન્ડિશન રિન્યુ કરાવીને સાહેબ નામદાર કોર્ટ સમક્ષ જમા જ કરાય.
જી
પણ સાહેબ અપોઇન્ટમેન્ટમાં 2 મહિનાનો ટાઈમ લાગે છે સાહેબ. જી સાહેબ.
ના
સાહેબ રિન્યુ અગાઉ બી સાહેબ કોર્ટમાં લીધેલા છે સાહેબ. 90 ડેઝનો તો ટાઈમ લાગે જ છે. અને સાહેબ આવી જશે તો વિધિન એ ડેમાં સાહેબ જમા કરાવી દઈશું.
મળ્યું સાહેબ આપને? મે આઈ રીડ ધેટ પેરેગ્રાફ? વિનોદભાઈ મનસુખભાઈ ઠાકર, ઇન્ડિયા ગ્રીન રિયાલિટી પ્રાઇવેટ લિમિટેડ તેમજ કંપનીની સહયોગી કંપની ઇન્ડિયા ગ્રીન ક્લબ એન્ડ રિસોર્ટ પ્રાઇવેટ લિમિટેડ કંપનીના ડિરેક્ટર છે. તારીખ 29/9/2009 રોજ આ કંપનીની સ્થાપના કરેલી અને જેમાં એમનો મુખ્ય હેતુ ઇકો વિલેજ ઝાપ ગામે પ્લોટો પાડી વેચવાનો હતો અને આ કંપનીના ચેરમેન તેમજ માલિક હોય અને સદર કંપનીની સ્કીમ મૂકી રોકાણકારો પાસેથી હપ્તા સ્વરૂપે નાણાં ઉઘરાવી રોકાણ કરાવેલ છે. તેના મુખ્ય સૂત્રધાર છે અને કંપનીમાં અલગ અલગ માણસો દ્વારા આ કંપનીના નાણાં ઉઘરાવી તારીખ 31/3/2010 સુધી કુલ 9,17,00,000 આવક ઊભી કરી અને કોઈપણ ભોગ બનનારને સન 2010 સુધી પ્લોટ અંગે દસ્તાવેજ કરી ન આપેલ હોય તેમજ હપ્તાથી પ્લોટ આપવાની સ્કીમ દ્વારા નાણાં ઉઘરાવેલા હોય, આમ કરીને ઇન્ડિયા ગ્રીન રિયાલિટી પ્રાઇવેટ લિમિટેડ કરારો કરી દસ્તાવેજ ઓછી કિંમતના તેમજ વિકાસ ફંડના લઈને નાણાં ઉઘરાવેલ છે. Now this is the allegation. Now allegation is in two parts. There are 86 victims whom sale deed has been registered by the present accused. So it's a very interesting it. Sale deed has been executed. Now the case of the prosecution is that sale deed has been registered at a jantri price. Normally we registered sale deed at a jantri price. And apart from jantri price, there are other development fee because it's a township. So we have to also develop the roads and other amenities. Therefore, we charged some development fee, which is a part of the total consideration. Now the case of the prosecution is, since I have done a sale deed, which is much below the price of which the amount I received, including my development fees. Therefore, the difference amount is liable to be refunded by the accused. This is the case they have made out. So that is not in dispute that the registered sale deed has not been done. So the reply on paragraph 9, if a honorable court may see, the list has been given of the victims. Now, first, I just column 1, if a losses may see, Prakash Bhai Lodha, that I want to demonstrate. Bharela Nana, 10 lakh rupiya. દસ્તાવેજની રકમ, this is a registered sale deed, 1,48,000. This is the jantri value we do. અને પરત લેવાના નાણાં 8,52,000. So the interestingly, the case of the prosecution is that amount which was taken as surplus from the persons who are the victims are liable to be refunded. And this is the entire case of the prosecution. There are 17 people whom agreement to sale was done, but they did not pay the entire amount of the sale consideration. We did not execute the sale deed. 17 persons, which are included in the list of total 86 persons. So there are two part of categories. 17 persons whose sale deed has not been done, because our case is that they have not paid the entire amount. And remaining persons whom sale deed have been done, registered sale deed, but the fraud which the prosecution wanted to establish, that more amount was taken from the sale deed amount. Therefore, they are liable to be refunded, and this is how the fraud is perpetuated. And therefore, they have attracted Section 3 of the GPID Act also. Now, the narration of the allegation which I just read over to the Honorable Court, the allegation is against the company, that is India Green Realty Limited, which is a public listed company. I have been arraigned as a managing director of the company, and this is how my role was introduced in the prosecution. Along with GPID section 406, 409, 420 and 120B is also attracted. So this is a very unique case wherein property is delivered through a registered sale deed to all the victims, and the case is made out by the prosecution is that you took a amount more than the amount of sale deed which is registered. Therefore, you perpetuated cheating and criminal breach of trust. This is the entire case. Now, I just want to read over the document. There are two documents. Total, yes, total there are 86 members. Total 86. Out of which 17 people who has sale deed is not been done. And remaining sale deed has been done. 86 persons. That is final. As no more. Not paid. That is my case. So 86 minus 17, around 69 remains. Whose sale deed has been done? Registered sale deed. Yes, sale deed has been done, which is a part of charge sheet also. There is no dispute. Development fee which I have taken. So now I have to satisfy. So I will divide my submission on two parts. One for the victims who have been sale deed has been duly registered, and for the remaining 17 persons whose sale deed has not been registered. Now, for the persons whose sale deed has been registered, there are two documents which has been executed by the company at the time of sale transaction. One is Banakhat, which is agreement to sale, and second is my registered sale deed. Now, I have to demonstrate to the Honorable Court that the amount which I took as a development fee, whether that is mentioned in the part of the contract or the agreement or not, as a part of development, because I cannot sell the barren land to the, it's a NA plot, basically. Therefore, for the township purpose, I have to create roads, I have to create clubhouse and other amenities to the allottees who are purchasing the plot in question from the company. Now, please, I want to refer one agreement to sell and sale deed from the charge sheet record to show that what is the actual transaction between the company and the allottee. Managing director. Yes. Other persons are all are independent directors. All are independent. There are two types of directors. One is a managing director who is accused number one, which application which Honorable Court is hearing. Entire documents which are signed between the allottee is signed by the present accused number one. There are no signatures on record or rest of the directors, yes. So for other directors, I have some other arguments that since they are independent directors, they have no role in the company to play because they are taken on board just for the purpose of compliance of the company law. Now, So now I will just read over the agreement to sale, which is a part of charge sheet of one of the victim, and then the sale deed was done subsequently. Now, if honorable court may have a copy of charge sheet, I am just referring to one page number 421. Yes, rest of the elements are same. All area, survey number, or plot number. And all. Yes. Now, please come to page number 420 of the charge sheet. 420. 420. Pardon? 420. As per the section alleged. Now, please see one I want to demonstrate. Yes. Its a witness name is Shankar Bhai Kashi Bhai Patel, and his name from the I'll just give his prosecution witness number 18, 18. 18, yes, PW 18. Now, may I, sir? Now, page number 420, losses of fund. Okay, I'm sorry. Online. Yes, Rajendra Bhai Patel. Now please come to charge sheet page number 313. That is a registered sale deed. Executed. There is no dispute. And in that that averment which I want to point it out, if honorable court may see. So that is not in dispute. Yes. Now they are claiming a case against me that now you refund the amount which has been taken in as a development fee. So how it would be permissible? Now the property has been entrusted by registered sale deed. Now how I could not understand the case of the prosecution, that how the refunded amount, which is a part of a development fee, which I have also shown in my income tax return also. It is not said that I have siphoned the money. And property has been developed there. Today I have a clubhouse. Today I have a roads. Today I have a plantation. I have a lake in the property. So there could not be a case of cheating or criminal breach of trust, because property is already entrusted. And suppose if they are aggrieved that I have to refund the amount, no civil suit has been filed till late for the refund of the amount by the said persons. Now, assuming in this facts of the case, whether the amount which I have taken as a sale consideration would fall under the definition of deposit of section 3, then my submission to the honorable court would be that the transaction of sale and purchase in a real estate would not fall in a definition of section 3 of deposit. That I'll just, yes. Now, in a sale deed, page number 321 of the charge sheet. Yes. Yes. That the sale transaction would not fall under the definition of section 3 of GPID Act, because I am not a financial establishment also. And one more contention to the honorable court, if honorable court may permit, that the allegation is against. So sale deed has been done. Now please come to 321 of the charge sheet. The sale deed, one clause which I want to point. Three 321 of the same prosecution witness 15, clause 4. Yes, sale deed, yes. Of the same witness. 15, yes. May I read clause 4? Yes. Start from page number 313. 312. Sorry. 312. Now, clause 4. May I read? The purchaser, that is the victim, shall use the said plot for only for residential purpose in accordance with the scheme so and so evolved, along with other lands of the vendor, and shall be entitled to use common facilities and amenities and other services in common with the other plot holders. So there is a clear reference of common amenities. Now the common amenities is defined in agreement to sale, which is of the same prosecution witness, which the Honorable Court would find start from page number 346 of the same prosecution witness. Three 46. And the condition which I just read it over at is at page 349. Same. So first there is agreement to sale and then sale deed. And there is an allotment letter. So all the documents are proper as per the exact real estate transactions. And there is a reference that the amount which been taken by the company as a sale consideration, which will also be utilized as 60% for the land price and 40% as a development fee. Because I cannot give a open barren land without any compound wall, without any roads, gutter amenities, which I just pointed out to the Honorable Court. So there are 69 witnesses as it is. So in support of my submission is that they have charged with 406 and 420. Now for 406, the primary consideration is entrustment of property. For 420, there cannot be entrustment of property. So here there is no case of cheating, because property is not entrusted to me at present. It is with the victims itself. So both charges cannot be go together. This is my first submission. Second, the allegation is against the company, India Green Realty, which is a company where I am a managing director. Now, surprisingly, the company, which is a separate legal entity, is not been arraigned as an accused in the entire FIR or charge sheet. So, assuming if an offense is committed by a company, and if I am a director of a company, the vicarious liability concepts applies that unless the company, who is a separate entity, is not joined as an accused in the present offense, then vicarious liability against the director would not be attracted. This is what the Honorable Supreme Court has clearly said in Sunil Bharti case, which I will just point out. And my third submission is that if we see the section 3 of the GPID Act, if the Honorable Court may permit me, then the consideration paid would not qualify in the definition of deposit. And even as a real estate company, I am not qualified as a financial establishment also. Therefore, even section 3 is not attracted towards me. So the opening line of section 3 says, any financial establishment which fraudulently defaults any repayment of deposit on maturity, along with any benefit in the form of interest, bonus, profit, or in any other form as promised or fraudulent to render service as assured against the deposit. So there has to be a deposit, there has to be a promise to return in terms of interest or profit. So in this case, there is no such promise of any return of profit or as on interest, because it is a pure sale consideration where I took a money and delivered my property in question. Every person, including promoter, partner, director, manager. So the definition is so wide that all persons are included in the alleged offense. Now the allegation, if it is against the company, where is the company is joined as a party, then how the charge would be framed against the directors and vicarious liabilities would be attracted. towards the other directors. Secondly, the signature on the Banakhat and the agreement to sell, assuming there is a case against accused number 1, I'm for the sake of argument, then the entire documents are executed by accused number 1 itself on behalf of the company. Rest of the accused, they are neither the signatory. Even in the FIR, there is no clear averment or role prescribed that how these other accused are involved in the charge of conspiracy also. That is also absent. Now, in the charge sheet, the prosecution has stated that till date I have executed more than 500 sale deeds of the entire land in question. I have a land bank of more than 700 viga of land. There's an entire circle of land. I have executed till date 528 sale deeds whose have been registered. There is no grievance to that effect. Now the grievance has come because they have attached a parcel of land of 80,000 square meters under the section 10 of the attachment, for which the remaining sale deed owners is not able to get their name muted in the revenue records because of this attachment. So another line of litigation has started because of this attachment. So in that application also I requested that total number of these people would be 12,000 square meters, assuming entire case against me. They have attached 80,000 square meters. I said you attach one survey number which would amount to 20,000 square meters. So entire 700 becomes 2 lakh, approximately 2 lakh kilometer, 2 lakh of square meters of area which I am holding. So I requested that if you remove the attachment of rest of the survey numbers, then I also propose to the prosecution that I am not able to get any finance over my property. Therefore, if that attachment is lifted tomorrow, yes. But how they have attached that in the middle of the portion, they have attached few survey numbers. So no entire, a patch is attached. Now, if the 80,000 square meters. I stand corrected. They have attached 2 lakh square meter of land. They have attached 2 flats. That amounts to total more than 8 lakh square meters total. 2 lakh they have attached, approx. Yes, they are attached. Out of which I proposed to them in the earlier round of my submission that you attach a specific one survey number which amounts to total 20,000 square meters. They have alleged a fraud of 12,000 square meters of land as per the total victim calculation if we done. We propose them that you attach 20,000 square meters, which is much more than what is they have attached. But you attach only one survey number. No, they have 2 lakh attached. Fraud is of total 12,000 square meters of land. 12 lakh square meters. So we propose to them that since your case is of 12,000 square meters of land, you attach 20,000 square meters of land in much addition we proposed in one survey number. And rest of the attachment, if it is lifted, then we would have an investor who is ready to develop the land and we get some fund and the remaining amount can also be settled. This is what we proposed earlier. Now, because of this attachment of 2 lakh square meter of land, my entire finance position of my company has been disrupted. Attached, yes. Even for the 17 persons whose sale deed has not been executed, in the pending this case, we have executed 7 sale deed to that respective owners. They executed sale deed to the person to whom the sale deed was not done. No, they have not. I have not taken extra amount. I have immediately done the sale deed. I have not taken any amount, which was according to me was outstanding, but I did not took it. 86 persons. Out of 17 persons were there whose sale deed was not executed. Out of which 2 lakh. No, for total 86 persons, they have attached 2 lakh square meter. For the refund of amount, yes. So for 69%, there could not be any outstanding amount because property is already been executed. The difference amount, yes, as per their case. And for 17 persons whose sale deed was not executed, out of for 13 people, 7 people I have executed sale deed not executed. Only Banakhat was executed at the relevant point of time. Subsequent 7% sale deed has been executed. 6 persons I have refunded the entire amount as per the prosecution case, and that has been submitted on record. 7% sale deed. 6% we have refunded the amount. And 4 people remain. That there also we propose that we have a land bank still there. So we propose to them that you execute the sale deed because we are not in a position to refund that amount, which is a big chunk of amount. And we have to also receive the remaining amount. But just to settle the score of dispute, we propose to them that instead of refund, you execute the sale deed. 4 people. So that these 17 people will out of the total 69 people. Then the case will remain for 69 people only. Where my case, as I just made my submission good, that there is no case of cheating, fraud or GPID. Yes. Now, if I read the prosecution witness number 15 statement for a moment, so that would have a same statement for everyone. Entire copy paste statement would be. Page number 309. 309. Very interesting statement. Yes. May I read? Yeah. Now, page number 309, a statement dated 6/5/2018. મારું નામ રાજેન્દ્રભાઈ સાકરચંદ પટેલ. ઓકે, રૂબરૂ પૂછવાથી મારા લખો હું ઉપર બધા માટે હા, આજ રોજ આ સાહેબે મને સીઆઈડી ક્રાઇમ સો મેં ઇન્ડિયા ગ્રીન રિયાલિટી પ્રાઇવેટ નાઉ ધીસ ઇઝ ફ્રોમ વેર આઈ એમ રીડિંગ. મેં ઇન્ડિયા ગ્રીન રિયાલિટી પ્રાઇવેટ લિમિટેડ કંપનીના છાપામાં જાહેરાત આવેલી. આ કંપની ઠેકાણો સો ખાતે આવેલી હતી. સન 2010 થી 2011માં હું મારી જીએમડીસી ઓફિસે હાજર હતો. જે દરમિયાન આ પરાસરભાઈ પંડ્યા આ કંપનીના પ્લોટો અંગે સ્કીમ વિશે અમોને ઓફિસ આવીને સમજાવતા હતા. અમો તથા અમારા ઓફિસે કામ કરતા બીજા અન્ય સભ્યોને આ સ્કીમમાં પ્લોટ લેવા માટે 300 વારનો પ્લોટ રૂપિયા 1250ના કુલ 3,75,000 એક સાથે ભરવાની હકીકત અમોએ સ્કીમ દ્વારા સમજાવવામાં આવતા અમોને પ્લોટ લેવાની ઈચ્છા હોય જાપ ગામે પ્લોટ આપવા જણાવેલ. જેથી અમોએ પ્લોટ પૂરેપૂરા નાણાં સ્કીમ પ્રમાણે સન 2010માં ભરી દીધેલા. જે ચેકથી સો એમ કુલ 1,50,000 ભરેલા, જે કુલ રોકડેથી તથા ચેકથી 3,75,000 મેં ચૂકવી આપેલ. ત્યારબાદ અમોએ સ્કીમ પ્રમાણે નાણાં ભરી દીધેલ હોય તેમ છતાં અમોને કોઈ પ્લોટનો દસ્તાવેજ મે 8/16 સુધી કરી આપેલ ન હતો અને અમોએ સન 2010 થી 16 સુધી અવારનવાર પ્લોટ બાબતે ઉઘરાણી કરેલ. તે અમોને આ પરાસર પંડ્યા તેમજ વિનોદભાઈ ઠાકર નાઓએ ખોટા આશ્વાનો આપતા હતા અને છેલ્લે તારીખ 1/9/2016ના રોજ જાપ ગામના તાલુકા સાણંદના સર્વે નંબર 100 પ્લોટ નંબર 100 રૂપિયા દિગ્વિજય વાઘેલા નામથી મારા નામે કરી આપેલ. જેમાં મેં દસ્તાવેજ વખતે રૂપિયા 3 લાખ ભરેલા. તે સિવાય દસ્તાવેજ પેટે યોગેશભાઈ પંચાલને રૂપિયા 100 આપેલા. જે જમીન ડેવલપમેન્ટ તેમજ મેન્ટેનન્સ તેમજ દસ્તાવેજ ફીના નામે નાણાં લીધેલા હતા. નાઉ ધીસ ઇઝ વેરી મટીરિયલ. there is an admission that I have taken a development, maintenance અને દસ્તાવેજ ફી. આમ આ યોગેશભાઈ પંચાલે અમોને પ્લોટ નામે 100 જમીન મેન્ટેનન્સ ડેવલપમેન્ટ તથા મેન્ટેનન્સ તેમજ દસ્તાવેજ ફી પેટે કુલ 4,80,000 ભરેલા. જેમાં માત્ર 90,000નો દસ્તાવેજ કરી આપેલ અને બાકીના 3,90,000 છેતરપિંડી કરેલ છે. સો ધીસ ઇઝ હાઉ ધ એલિગેશન ઓફ ફ્રોડ એસ્ટાબ્લિશ. આમ ઇન્ડિયા ગ્રીન રિલેટિવ પ્રાઇવેટ કંપનીના માલિક વિનોદભાઈ ઠાકર તેમજ પરાસર પંડ્યાએ અવારનવાર મળી પ્લોટના કબજા ભોગવટા બાબતે અમોએ વાત કરેલ. તે અમોએ ખોટા બહાના બતાવેલ હતા તેમજ પ્લોટના દસ્તાવેજ પ્રમાણે અમોને કોઈ પ્લોટની સીમા નક્કી કરી આપેલ નથી કે કોઈ પ્લોટ કબજો આપેલ નથી અને અમોએ સન 2010 સુધી એવું જણાવતા હતા કે જમીન લેવલ કરવાનું બાકી હોય પ્લોટ ફરીથી દિવાલ કરી આપીશું. આ દિન અમોએ પ્લોટ કે અમોએ ભરેલા નાણાં પરત કરેલ નથી અને કંપનીમાં જતા પરાસભાઈ પંડ્યા તેમજ વિનોદ ઠાકર હું મળતો અને મારા પ્લોટ આપવા માટે જણાવતો, પરંતુ અમોએ પ્લોટ બુકિંગ કરાવેલ ત્યારથી આજ દિન સુધી તેઓ એમ કહેતા કે આ પ્લોટ સ્કીમ વાળી જમીન એને થયેલ નથી અને આ સ્કીમની ફાઇલ કલેક્ટર ઓફિસમાં પડેલ તેવું જણાવતા જેથી અમોને ખોટા વચનો અને આશ્વાનો આપેલા. મેં પ્લોટ બુકિંગ કરાવતી વખતે ઇન્ડિયા ગ્રીન રિલેટિવ પ્રાઇવેટ નકશો આપેલો જે નકશામાં A1 થી 100 સુધીના પ્લોટનો નકશો હતો. જેમાં મને A142 નંબરનો પ્લોટ 300 વારનો ફાળવેલો હતો જે મને ફક્ત કાગળ પર બતાવેલ, પરંતુ મને આ ઇન્ડિયા ગ્રીન ભાગીદારો કદી જગ્યા પર આવી પ્લોટ જમીનો બતાવેલ નથી. તેમજ આ બાબતે મોજે જાપ સ્કીમમાં ઓલ સ્ટેશન સિમિલર. યસ, So main important para, if the Honorable Court, paragraph 3, where the distribution of amount which has been already admitted with regard to maintenance and development, now they say, now you refund that amount. Since my sale deed has been registered only for this amount. No, sale deed has been executed with, but sir, but the statement, sale deed is part of record, which is 312, 1st September 2016. So that is what he's saying, but sale deed is a part of charge sheet. This is the case of the prosecution. કરી આપેલ છે સાહેબ, એવું લખ્યું છે, કરી આપેલ છે. માત્ર 90,000 નો દસ્તાવેજ કરી આપેલ છે. So this is the that is totally incorrect because the state has already attached my plots. I have also submitted 500 photographs of the entire scheme, which is a part of record, to demonstrate, to show my bona fide whether entire township exists on that area of plot. Even the prosecution from the Mamlatdar can also report may be called for. Actually, the entire portion of land and township still exists. And this is how the case has been made. Now that you refund the development fee, you refund the sale deed charges. Now, whether on this footing, whether the case would be stand even to frame a charge against me. Yes, not signatory. Even agreement to sale and the sale deed, the authorized signatory is the director accused number 1, which I'm arguing. Rest of the directors even have no role in the alleged transaction. Even they have no role to any of the signatures. Just bare awareness has been made. Otherwise, even the no role has been specified in the complaint that how X person is responsible, how Y person is responsible. Because if in a case of a fraud by a company and alleging role of the directors, the Supreme Court has said that clear bifurcation of role is required. Otherwise, if you don't make company as a party, then directors would not be ever liable. Because opening life of the case of the prosecution is against the company, India Green reality, not against the individual persons. Even he has not, if the investigation is so, I cannot come on the part of investigation, but they have not even checked the ROC records also. Public Limited, India Green Limited. But in 2016, it was private limited. Now it is a listed company. Relevant point of time, private limited. So the case is that it is not a case of any scheme where there is no land exist, there is no document on record, there is no sale deed has been executed. This is not a scheme. Mere breach of Supreme Court. I just got the judgment of Supreme Court, latest judgments, which says the mere breach of contract or non-performance of agreement, assuming a case against me, would not attract any criminal liability, because it is at the best is a case of a civil dispute. At present also, there is no civil dispute has been filed by any of the parties. No even single notice has been given that you refund this amount. Because they are aware, because in a case of a real estate, they would not stand footed in a civil litigation. Therefore, they converted entire breach into the criminal prosecution. This is the only litigation. 86 persons. because in the next line, in my next submission, I'll point out from the categorically section wise from the awareness that this evidence would not be even enough to frame a charge under the GPID or the IPC offense. And I have got a judgment of Orissa High Court of OPID Act, because in Orissa, similar nature of act is there in Orissa. There's a similar facts of a real estate transaction, a GPID like OPID case was registered. There the Honorable Orissa High Court has said that definition of section 3, which I just read, of deposit, sale consideration would not fall. And company, yes, may I permit it to tender? Citation. I'll just make a list because this case is a very good reference of recent development. Similar case to of my nature of real estate transaction. And the Honorable Court has clearly said, place it. Please, I'll place with a note of like with for the radius. There is an attachment application of this CMA1 is also listed today, where I have also filed my reply against the attachment, which I just referred to the Honorable Court of the entire square meter of land. One. Sir, I have also filed an account.
Application
Exhibit
seven.
7. Sir, A exhibited, sir, 17. 268.
સિવિલ
હા
આ 268 મારી
અમે અરજી કરી છે ફોર મોડિફિકેશન.
સેક્શન 7 મુજબ એમની હતી.
ના નથી થઈ, હવે પેન્ડિંગ જ છે, એડ્યુડિકેટ નથી થઈ. ના એ સાહેબ એ બીજા કેસમાં કરી હતી. ના એમાં એ કેસી હોલિડેસ બીજી મેટરમાં કરી હતી. આમાં તો સર નથી એડ્યુડિકેટ થયું. હા સર, એમાં શું થયું કે nomenclature was in criminal, therefore the honorable court has passed a circular that for the attachment will be treated as a civil in nature. ના, it was converted into CMA. હા એવું છે. ના હા, એટલે એ પહેલા સાહેબ એવું હતું કે જે અટેચમેન્ટની એ CMA, હા CPC ની છે, ક્રિમિનલમાં નહીં આવે. યસ.
પાછું ક્રિમિનલમાં આવ્યું છે. પાછું ક્રિમિનલમાં કન્વર્ટ કરવાનું છે. એક લોર્ડશિપનો ઓર્ડર એવો એટલે ફાઇન્ડિંગ જેવું જોઈએ આવશે આગળ.
I have not come across such. CMA સિવિલ ટ્રીટ કરવું
એવું જ હોય
હા,
પણ લોર્ડશિપ
because attachment proceeding would normally govern as per the CPC powers under the act also. Powers of civil nature. Therefore, it is treated on the civil side.
લોર્ડશિપ સમીર દેવાઈ સાહેબના કેસમાં ફાઇન્ડિંગ એવું છે. It's a criminal proceeding. Only one sentence.
So it is a nature of quasi criminal, half